Hey everyone, I'm Anusha and you are welcome to Law Minds. Today I'll be discussing about what are house rent agreements, lease and tenancy and how to negotiate them. Agreement for renting a property is a legal document that almost no one can avoid. So now let's move to a term called lease. What is lease? It is a transfer of right to use the property which may be for a specified period or for perpetuity provided that a price is paid for it. It is not possible to evict the leaseholder when the lease is in existence unless there is a provision for terminating the lease agreement provided in the lease agreement itself. What leads to a lease to tenancy? Tenancy is the right to live in a building or use land owned by someone else for a specific period in exchange for paying the rightful owner a sum of money, which means tenancy represents a form of temporary possession or right to occupy a specific property where an individual known as the tenant is granted permission to use and inhabit the premises owned by another person, that is, the landlord. The legitimacy of this occupation is solidified through the establishment of a lease or rental agreement, a legally binding document that outlines the terms and conditions governing the landlord tenant relationship. Now let's move to how to ensure a effective lease deed. First, you will have to find out who is the actual owner. It is important that a lease agreement is signed by the real owner of the house property. You can ask the owner for the documents which shows his name and identity. You can also request the owner to examine the title deeds of the property which will mention how the land was originally allotted by the government of authority or etc. and how its ownership is transferred. This must be done before paying the security deposit or any type of advance payment. It is difficult to trace ownership of agricultural land because it may have been transferred to many several private hands through partition, intra-family transfers, etc. for a number of years. If the person is leasing the property is not the owner of the land, then you should find out if he has the authority to lease it. It means that the person entering into the contract is not the owner but is someone else, that it should be checked that whether he has the authority to lease the property. If one enters the contract with a property of which he is not the owner, then the real owner can evict him at any point of time. Means the real owner can evict the tenant at any point of time, and the tenant can ask for the compensation to the person who had acted as the owner. So it's better to check all the documents before entering into the contract. Now let's discuss about some important clauses which can come into the agreement according to the nature of the agreement. First is the subletting clause. Subletting is authorized provided the owner consents to it at the time of agreement. If not, the lessee cannot sublet the property, but he may use it for himself. However, if the agreement allows for subletting, the landlord cannot remark on who he should and should not sublet to. The lessee is responsible for all aspects of the subletting. And in case of restaurant, factories or any other property with a significant investment in installation expenses, it is preferable to have a less stringent subletting clause. If there is a clause allowing subletting, it should include a provision for paying a fee in exchange for the subletting. Next comes the payment clause. Payment in exchange for enjoying the property should be clearly stated in the agreement. The period from when the payment arises, how the party shall make the payment, the recipient of the payment, the consequence of the non-payment or payment delay. These are the parameters that must be included in the agreement. Next is the increase in rent clause. It is also important to clarify any rent increases that occurred throughout the tenure. Sometimes there is a 10% rise in the rent rate each year. In this situation, one must determine whether it is simple or compound increase. It is preferable to add a condition in the rental agreement that explicitly states that there will be no rise in the rent rate. Next comes the guarantor clause. A landlord may or may not add a guarantor clause in an agreement. The guarantor is kept in case the occupant does not pay or pays late. The guarantor is then responsible for making good on the losses. Although it is not common practice, it is useful when there are conflicts between the landlord and the tenant. Next comes the maintenance charge clause. The landlord bears the monthly maintenance expenses of the property. But the landlord may also collect money from the occupant. However, it should be clearly stated in the agreement that the landlord and the occupant will pay the charges, and in the case of monthly electricity bill or any other utility bill, it must be specifically discussed between the landlord and the occupant before agreeing as to who will bear the expense. Next comes the wear and tear clause. The agreement should expressly say that there will be no cost for normal wear and tear on the property. But if there is any direct act or negligence that has resulted in the loss, the occupant must face the expenses. Next comes the repair works during occupancy. The provision that outlines who is paying for the repair charge expenses is an important clause. If the repair is minor, the burden can be transferred from the landlord to the tenant. However, if the repair costs are very expensive, then the landlord must bear the financial responsibility of maintaining the property. If nothing is indicated, the landlord is typically responsible for paying the taxes. Even without mentioning it, the occupant may be allowed to deduct the TDS. Next comes the resolution clause. If it specifies which court will hear any dispute that arises between the landlord and the occupant. It is the court that has jurisdiction over the city in which the property is located or the court that has authority in the city where the landlord lives. Then comes the general nuisance clause. The landlord must ensure that the agreement states that he would take care of any nuisance caused by him to the landlord or the neighbor. Although it has no practical use in real life, it is prudent to include such sections in the agreement. General concerns with leasing or renting of any kind. The occupant should seek authorization from the landlord before making any significant changes to the property. The agreement should include a section stating the landlord's authorization to enter the property at a specific time. So, this was about the lease, tenancy, and the checklist to ensure effective lease date. Thank you.